Alright, ebuson mo bibia kwa ba mfamra 2K ni sem loso e wo YouTube so ase ebuson aba ensem ahodo a ekoso e wo mema se na de beso ahwefo enyina na ebuson ensem ni nyina so e fa chese eye justice toku no ho san so ana eye prof ma ekwei ada buson abede san sem ba beto anim no na de te nyina nse e be kwani akwa akwaje ensem ni nchire mu abra chese prof Mike ere ensem bi ato eye Chief Justice Tokunu enim na ebusu ansa na me so nya subscribe family YouTube channel ya na wa subscribe e de ama na se me bro ran se mi ma de tie nyina ne se yes say no Prof Mike e de ba betu dwa se e ya de se omo ye nhihye bi e de agu akwan mu na san nhihye na omo ye no wa bra bibia besise kim na chese ya de se CJ o so timi free na kunya so na se omo de ba bonten na saafo no ba be no se me nso me nti ase me betwe nsem no sere ne abase ne yidi anya adwuma once odi decision be ba no e wo so itimi flo ho no na okọ ba bia e wo so okobia na biso nsem nya enchirim e wa ase be kọ ne akwa akotie iwi a onso wo comment bia na de ato comment section ho no na bibia so etimi ai kama midin e de kwam gentle
the issue that I've discussed with you, and it must be resolved as a preliminary issue because if you were to put me in such a trial, I wouldn't go. And I wouldn't plead. I wouldn't say anything. You can do whatever you like. Because I would like the world to hear. And I bow out according to what is being heard. Putting a person in a room, coming out thereafter to say what occurred there. When in this country we have so much controversy over matters that even all of us are seeing and hearing. You will be surprised at all the interpretation.
You were saying that if you were in the shoes of Gertrude Tokon, you would not appear before this committee.
I say, if it is going to be secret trial, I won't appear. You can do whatever you want to do.
Because you don't trust the process?
No, it's not a matter. You see, I wouldn't want to single out any particular event. Okay. But as a matter of general principle, I am telling you, no Ghanaian would like to go through that kind of process. I mean, it is a very, very important principle, and it's a human rights issue. And that's why I say that human right of the person who is the victim and accused in this case might be seriously examined. If that fair and open trial. And then we can all see, I'm telling you honestly, if a disciplinary action is given against a messenger in the judiciary, you know he or she will be entitled to take the matter to the High Court when a decision is held against that person. And the Constitution says the person is also entitled to appeal to the Court of Appeal. And then you can take it to the Supreme Court. And furthermore, to the review committee of the Supreme Court.
Right.
But in this particular case, the person who is being tried in secret cannot even appeal. So let the world see it once and for all. It is a very, very important jurisprudential and human rights issue. Nobody wants a star chamber court. Nobody wants secret trial. Even in our traditional system, which is guaranteed by this constitution, our traditional law, customary law, and so on. That customary law, whether the case is a FISEM, that is a small family case,
right, or
it is a MIND-SEM, that is a proper national or village or town matter, the trial must be held in public. And on certain days specifically set, and people can come and listen. Some people go to the court just to pass time. Do you know that? To go and hear cases. A person is entitled to hear cases in court.
In this case, it's even unclear whether the committee has started its work. It's unclear whether the suspended CJ has appeared before them. But it's not too late to make changes.
I think it shouldn't be too late. And whatever has been done up to this stage, the Supreme Court should be able to go into this matter and declare whatever has happened so far null and void, and then start open trial. Because a Ghanaian's human rights are at stake. And it's very, very important. And that is why, look, there are many people who, if this is how a Chief Justice can be removed, will tell you, I'm not interested in the post.
In the post?
Oh, no.
Prof, indulge me.
It will happen.
Indulge me. Let's spend some time on this matter so that the understanding is clear.
If this is how a judge can be of the Supreme Court can be cocooned into some room, 5 people, nobody can see some, nobody can hear some, and then after somebody will come and tell you the verdict, there are many people I respect strongly in the bar, at the bar, and at the judiciary who will say no.
This is a very important point.
It's an important point. We will be destroying the judiciary if you go this pathway. And I will come and be a Chief Justice. What for? I say 5 people chosen by 1 man. I'm not talking about even the person who chose. 1 person chooses 5 people of his choice, and then they can come out with any judgment which is done. The process takes place in darkness. I mean, in the closed room. Oh, no. There are many people who want to be judges.
And so you say that the court must declare whatever has happened null and void.
I say, I don't know even. But it is possible. I'm not saying what must be done. I'm not clothed with that power or authority.
You are suggesting that the court
But it is possible that the Supreme Court, having by the full bench, had this matter on the purposive factor consistent with the basic formulation which precedes the judiciary, that justice belongs to the people and it is administered in their name and on their behalf. If the thing is mine and you are administering it on my behalf, I should be able to come and see some.
But how would this work when whatever is happening is a constitutional, steps enshrined in the 1992 Constitution, where the president is only a conveyor belt in this matter and is asking the process to flow? The court has no role whatsoever. So is it a tax, for example, you are prepared to take in the court?
The power
in terms of uplifting the human rights of the individual, in terms of opening the process up to ensure fairness and transparency.
It can be done. That is why the Supreme Court is there, to interpret the Constitution. Because I've given you parts of the Constitution which say otherwise. I've given you the jurisprudential history of secret courts, which we don't want. In the United States, and this is a law that everybody who has been to law school knows, Marbury against Madison, a fundamental issue which changed the face of the law and gave the judiciary the power to even quash laws made by Congress in Parliament. It was not specifically provided for in the Constitution. But the judiciary and its functions, which had been given it, the court, led by Chief Justice Marshall, came to the conclusion that, and the logical conclusion, that if we are going to go by the rule of law as so provided by our Constitution, then the law must take precedence over everything. And everybody, including the legislature in America, the president in America, he can declare what you have done ultra vires, beyond law, and for that matter, make it null and void. This is the purposive interpretation of a Supreme Court. And that is very, very important, because it tells you, marry all the principles. Don't just look at one provision and then say, hey, I've got something to run away with. That is, it must be done in secret. How do you reconcile it with the basic principles underlined in the Constitution? It is something that the Supreme Court must look at.
So under the circumstances, under the current circumstances, you say that if these steps are not taken, if a person, under the circumstances, if these steps are not taken, a person appear before a committee whose hearing is shrouded in secrecy, then you're already gone.
Well,
more especially when the person who is facilitating this is responsible for selecting who should hear your case.
it is serious. And, you know, there are so many political angles which I wouldn't want to tread into. I want to restrict myself to the obvious. Let everybody see clearly that. As for this provision, that one man can choose 5 people, and then they will go and sit in a room alone with the so-called accused, and come out with their decision on the person, it's not fair.
But somebody must bring the Supreme Court, somebody must bring this to the attention of the court. Is this something that you're prepared to do?
I don't see why, in fact, maybe nobody has taken the matter to court still. Some serious Ghanaian must take this to the Supreme Court. And it is an interpretation that must be made by that court. And let them all, in their conscience, examine whether if it were me, would I like myself to be subjected to this? Because, you know, if you don't take care, a very dangerous precedent will be set. And I tell you, it will be
time bomb on a time bomb. As far as this matter is concerned,
time bomb is too strong an expression. But
this is an arm of government, supposed to be independent, being removed by another arm, and there's no remedy whatsoever.
And that is why I ask for a constitutional reform. And this thing is in black and white in my recommendations. My article at the IEA, published some 15 years ago, titled Countervailing Authority, it is there. My alumni address at the University of Ghana, it is there. We must change these things.
I will come to the attempts to review the Constitution, but because we are in the EU, should be sufficient enough to establish a prima facie case against a sitting CJ, since Article 146 doesn't give us that clarity.
You see, there is a case going on. We may say the matter in that regard is sub judice. I wouldn't want, and something has been said to have a prima facie case already. I wouldn't want to say anything that will prejudice that. I want to take myself out of the controversial areas.
But you say that it is too easy as in the present circumstances to remove a
it
chief
is too
justice.
easy. It is too
and
easy.
Some say the threshold what is constituting the case against her, the threshold is so low.
I wouldn't say what is constituting the case actually. The threshold is low because I don't know all the charges. So I don't want to comment on that. I don't know.
The matters that are already in the public domain, probably following.
Those things are supposed to be allegations.
These are being trumpeted by very senior government officials, and they say that they are even telling us the response of the Chief Justice to the extent that the communication officer of the NDC says that even when the matter was brought before the Council of State, out of the 31 membership, 30 voted in favor for the Chief Justice.
My dear friend, the person who said all this, if it is true, the Council of State was not established to be brought into the public light like this. If the Council of State have decided upon a matter in a certain way, it is not for you to come and tell the public what the Council of State, who are advisors to the President, said to the President. I don't know how any public officer will go on this tangent. And it's unfortunate. You mean to say that person really, I have not heard it. But if it is really true, to protect the person who is the subject matter of the trial.
Right.
Some people say, oh, it's such a high office and so on and so forth, that whatever happens should not be washing dirty linen in the public and so on and so forth. But first and foremost, the dirty linen has already been washed in the public.
Absolutely, by the fact that you've been accused of...
Exactly. All manner of things.
Right.
So, if it is for the benefit, that's what I'm talking about, a purposive interpretation, which the Supreme Court has seriously taken account of, since this was actually first hammered by Professor Justice Dateba. It's a very, very important thing because it goes to the root makes you understand why the provision is there at all, and for that matter, the application thereof. So it may be said that it is there for the benefit of the Chief Justice on trial. I don't want to talk here about a particular person, whoever is the Chief Justice on trial. But as I said, the matter is already in the public realm.
It is. Indeed, people are even